Welcome all and welcome to part 2 of our webinar series featuring Legalese with the Ladies. My name is Sean Whalen. I am a co-founder and the CEO of HopSkip. For those of you who are not familiar with HopSkip, HopSkip is a software platform for planners and hoteliers to source room blocks and meeting space at hotel properties. And since our platform includes the RFP, proposal, and contracting process, we knew it was important to understand how COVID-19 has impacted the sourcing process. So in addition to many conversations within the planner community, we've been working with today's presenters over the past few months on some new features that are helping the planner think about the right contract language to include upfront when initially sending their RFPs, and we wanted to continue sharing some of those learnings to the rest of the meetings community. So that's why we brought you today's session, Risk Management in Meetings Moving Forward, featuring Barbara Dunn, who represents group clients, and Lisa Sommer Devlin, who represents hotel clients, to incorporate both perspectives into today's conversation. And with that being said, I'm going to pass it over to Lisa and Barbara to kick off today's content.
Great, thanks, Sean. Good morning, everybody. I'm the one that's clicking through the slides today, so I'll kind of be taking a lead on some of this. But we want to start out just kind of telling you where we're going to be in this presentation. We're going to have our presentation on risk management moving forward. We're going to try and save some time for Q&A at the end, and we're going to have a couple polling questions just for fun. So let's start out with Barbara and I introducing ourselves. Barbara?
Hi, good day, everyone. Nice to be with you. I'm Barbara Dunn with Barnes & Thornburg, based in our Chicago office. I represent groups, mostly nonprofit organizations, as well as for-profit organizations in connection with our meetings, conventions, and trade shows. And I'm delighted to be here and to partner with our good friends at HopSkip, and of course, my dear friend, Lisa Devlin.
Thanks, Barbara. And I'm Lisa Sommer Devlin. I'm an attorney located in Phoenix, Arizona, and I exclusively represent hotels regarding group and convention-related matters. So I've been working with Barbara. As a matter of fact, I just saw I have an email from Barbara today on a matter. Barbara and I work together frequently, both doing presentations like this and also representing our respective clients against each other. So it's fun when we get to do things together like this. Before we begin, we do want to thank everybody that gave feedback regarding our last webinar. We went through it, the HopSkip team went through it, and we got a lot of very important information out of that, so we really appreciate you taking the time to do that. We also want you to know that HopSkip really is committed to working with the planners and the hoteliers that are using its platform, and so don't be surprised if they reach out directly to you to ask you for input or ask you for how they can make things better for you, because they really want to be involved in this process. One last little thing before we begin. Barbara, you want to give them our legal disclaimer?
Oh, yes, absolutely. Well, although we're both lawyers and we love to give you our opinions and our advice, they shouldn't be treated as legal guidance. We definitely will recommend that you follow up with your legal eagle. We're always happy to take your questions of general nature and again, certainly opine on that. But keep in mind, of course, every situation is different. And I think in particular, today's environment illustrates that even more so than we even thought about. State law varies, contracts vary, etc. So bottom line, self-serving it may seem, talk to your legal eagle. As I always remind clients, Lisa, it's easier and cheaper to keep you out of trouble than to get you out of trouble.
Absolutely true. So before we dive into going forward, we do want to kind of talk about, highlight some things we talked about last time. It's important to understand that the COVID-19 impacts are unlike anything we've ever seen in the meeting industry or really in the world ever before. So there is not law that directly addresses this. The law always lags behind the circumstances of whatever is going on because it takes years for cases to get through court proceedings and for new law to be made. So everybody in this circumstance is dealing with very uncharted territories. The pandemic of 1918 was not the same as this, even though it was the last really big pandemic. So there's really no legal authority out there, and there's no legal authority with how to go forward. So You're going to hear Barbara and I say this over and over again throughout this presentation. Partnership, working together, trying to work out deals is far better than drawing legal lines in the sand, because if you draw a legal line in the sand, you may turn out to lose. Right, Barbara?
Yep, absolutely. I agree with you, Lisa. And you'll hear us say that word a lot, flexibility. And although you've probably heard that word used in other contexts over the years, I think it's particularly important on the road forward.
Exactly. So let's talk about issues to consider going forward. Barbara, why don't you jump in here on these kinds of things and how they may impact meetings?
Absolutely. Sure, Lisa. So, you know, as states begin to reopen in the United States, we are seeing the limitations on gathering sizes that back in March went from 250 people down to 10 for the month of April, essentially, then back up to 50 and so forth. States jumped in, states started making their own criteria. So many states, and I so appreciate all the hellos and shout outs that you all have been putting in the chat box to show that we have all of our friends from across the United States. The circumstances, of course, differ in every state, but also city and county. So there are certainly cities and counties. I'm here in Illinois and Chicago. We're not going to be able to have 50 people together until we get a vaccine. So that's just our limitations on gatherings. Other states are obviously different. So it is very important to check, obviously, as you go. And as we all know in this situation, things change daily, hourly, potentially. So staying on track with that is important. Social distancing requirements. To me, this seems to be one of the perhaps few certainties that I see, at least in the short term going forward. That is the health experts and, again, state, cities mandating social distancing requirements. We've heard obviously a lot of industry discussion of late as to different room sets to allow for 6-foot social distancing and all the things that come along with that. So groups are evaluating their meetings, conventions, trade shows, figuring out how they might be able to be set with appropriate social distancing in mind. And we may see these social distancing requirements stay as requirements at that state or local level, or we may see them shift to recommendations. But as many of you probably saw on Monday, the CDC issued new guidelines, and we have the link included for you at the end of this presentation, reiterating both the importance of social distancing as well as the masks or face coverings, Lisa, which I know continue to sort of be the controversial aspects.
And if I can jump in on that's one of the biggest issues that I see going forward. As I mentioned, I'm from Arizona, and in Arizona, our governor is not mandating wearing masks, but individual mayors can. And when I'm out and about, as little as I am these days, I'm seeing limited use of masks. And I think one of the biggest challenges that we're going to have going forward, whether you're a planner, a meeting sponsor, or a hotelier, is how you try and get compliance from people. Because, you know, I gave an example to somebody yesterday saying, look, if you're having a wedding and you set the wedding with social distancing in mind, and suddenly, you know, drunk Uncle Joe is sitting next to somebody, you know, who is going to go up and tell him not to do that? And there's no real guidance on that. And in today's climate, I'm not sure if I'm a hotel, I'm going to expect my employees to face getting punched in the face by drunk Uncle Joe at the wedding. And it's a real issue, and it's going to be a hard thing to deal with going forward, which is something you're going to have to focus on with your partnership, again, in your planning and executing in the event of who's going to take that responsibility and how far you're going to go to try and enforce compliance. What do you think about that, Barbara?
No, I absolutely agree, Lisa. I'm coming off a client board meeting yesterday and evaluating whether to go forward with the meeting, and the board was split in half over the face coverings. Many felt not necessary, others felt absolutely necessary. The issue of enforcement came up. I like the illustration of Uncle Joe. Actually,
we all have one.
Actually, the idea came up in our session, though, about hiring security, professionally dressed, who would casually enforce the rules without, you know, being the big hammer, so that you weren't putting the group or its staff members in an awkward position. So I thought that was a good strategy. You know, cost is going to be an issue, Lisa, and I know as we go through the program today, we'll focus a lot on how meetings are going to change, and labor costs, that's going to be something that's definitely going to change if we need to have the security in there to wrangle old Uncle Joe.
And the other thing that Barbara and I often recommend is asking your partner to provide assurances of their ability to perform. That's something that's not done under the law a lot, but we both think it's something that should be. If you think that the other party to your contract cannot perform or does not intend to perform, you don't have to wait until the date for performance arrives. You can go to them and say, hey, based on these circumstances, I think you can't perform. Tell me how you intend to do that. And you have every right to ask that. And again, you should be having those conversations. Don't make assumptions about what your partner can and cannot do. Ask the other party to explain to you how they intend to go forward. Waivers, we've been hearing a lot about waivers. I heard that there was some discussion that for Trump's rally in Tulsa, he's going to ask attendees to sign waivers. I think Barbara and I are in agreement on this one. Pre-injury waivers the enforceability varies widely between state to state, but in general, it's very limited. It's usually limited to recreational activities that are very much voluntary, like skiing or something like that. It's rarely are they enforced when it comes to something like going to a meeting or a regular activity. Are they enforceable? Barbara, you want to talk about that?
Yeah, the answer is maybe, because it does depend on state law. It will likely also depend on the facts and circumstances. And then just to dovetail what we said at the outset, Lisa, unprecedented circumstance. I mean, essentially what a release and waiver is that you're asking that person to give up the right to sue that organization on behalf of themselves and their family members. So to say, that you're going to give up those rights in order to come to the meeting is a big deal. And it should be treated as a big deal. And whether that would ultimately be enforceable, again, remains to be seen. But there definitely is an issue and discussion on this on the going forward and the desire to have it enforceable. Releases have to be made knowingly and voluntarily of all the risks. On the knowingly piece, obviously living, as we all are, in a pandemic, there is this question as to whether a pandemic is already an assumed risk, right? Something that we all do when we leave our homes or stay in our homes these days. They have to be signed by people who are at least age 18. The risks coming out of it need to be foreseeable. Again, we talk a lot about recreational activities using release and waivers, and someone gets hurt, tripping during a 5K fun run, that's a foreseeable type risk. So again, the scope of it is limited as well, whether it would cover the sponsoring organization, whether it would cover the venue. Again, these are all issues going forward. And how it's accepted. I've seen many examples in recent past where event organizers choose to treat a waiver as similar to how we treat a waiver for photography and video recording. In other words, by registering for this conference, I agree to be photographed, recorded, and click here. And that's not going to cut it. I think that part, because you're talking about someone giving up a legal right, and you certainly, while on the photo side you have some rights, nothing like you're giving up on the release and waiver side. So,
well, and if I could jump in.
Signature, Lisa? Yeah, please.
If I could jump in on that, I also want to add that parents cannot waive their minor children's rights, and a lot of people think that they can do that. And again, policing these waivers, who is the person signing it? Do they really have the right to sign it on behalf of somebody else? So I think that's an issue. And even if you get anybody to sign them, they still can sue you. People, file suits after signing waivers all the time. Anybody can go out and sue anybody anytime they want to, as long as they're willing to pay the filing fee. So it may or may not deter suits. But it's also going to be hard because the real response in these situations is if somebody comes in and sues the hotel or the meeting planner or whoever it is and says, I got COVID-19 at your event, they're going to have a very, very difficult time proving where they got COVID-19. Even if there were a number of people at the event that got sick, it's a very difficult proof process. So I think that waivers aren't going to add that much more protection. And for me, I think the optics of waivers is is a bad idea? Do you really want to say to your attendees, hey, come to my event, but you could get sick and die, so sign this piece of paper? You know, I'm just not sure that that's the way you want to go forward. I think you probably would be better off on both sides talking about how you're going to protect them, which we'll get into, rather than saying, you know, can't sue us if something goes wrong. Do you agree, Barbara?
Absolutely. Optics are critical here, and it is important to take that into account. Keep in mind, too, this is a sensitive issue for people. It's a polarizing issue in some respects, but it's sensitive. And there are people that are grieving. There are people that are impacted by this disease going forward. So with all the unrest that we have just generally in society and all the rest, you know, this is something where groups could definitely get hammered on social media or otherwise for putting out these release and waivers when the utility is likely more limited. As you mentioned, Lisa, my guidance to clients has been on risk avoidance and the things that we'll talk about coming up.
So that leads us into something that Barbara already mentioned, a doctrine that a lot of lay people don't know about called assumption of the risk. And basically it says, and this comes, the first bullet point here is the black letter law on this, so to speak. Basically what it's saying is, if you know that you're going out to engage in a risky behavior and you understand what the risks are and you go ahead and do it anyway, you probably can't sue anybody as a result of that because you are assuming that risk. So if you know going to a hotel to a meeting could expose you to this disease, you would probably not be able to sue the hotel. Or at least there's a legal argument about that. Barbara, what do you think?
Yeah, that's definitely been the read as well on our part. And so again, you know, while folks might claim ignorance in some respects, or perhaps use the fact that states have reopened as a way to say that now I understand it's not a risk. Again, all signs point to the contrary, but I definitely think it's something that would be raised on the defense of this claim. Again, as Lisa pointed out a moment ago, the answer to the question, can you be sued, is always yes. Courthouse is open 365, 24/7 online. And my add-on, as you know, Lisa, I think I said this in the last program too, is that plaintiffs' lawyers need to send their children to college too.
Yeah, that's true. That's true. So having analyzed, what are the legal issues, what could happen out there? Do you need new clauses in your contracts going forward about safety issues? Barbara, and I think Barbara and I agree on this, but I'm going to let her take the yes and I'll take the no. So what do you think, Barbara?
Yes, I think that clauses as to safety can be very helpful. Having said that, as we'll all say, just having a clause doesn't make it so. And there's so many more factors that go into attempting to make a safe environment for the meeting. So yes, there are unprecedented circumstances. Our industry has been fantastic. All the hoteliers and the venue folks listening on the webinar today, thank you so much. You've gone out front on all of these issues relative to health and safety. And in particular, understand that from the group's perspective, the groups really care, and your employees at the hotels and venues are really important. And so first and foremost, when I talk to clients, they just want to know what is the hotel doing to keep employees safe. That's important to them, regardless of how that might impact their particular group. But of course, understanding what those protocols are, understanding what those standards are, that does become important. When it comes to compliance with laws, Lisa, we have those provisions typically in contracts. You see that you'll be in compliance with laws, and we talk about, fire, safety, health, etc. Again, with regard to things like social distancing, or as I saw in one of the comments pop up, maybe we should start referring to it as physical distancing, which that makes sense to me. I think there's some standards. So Lisa, my approach would be to have placeholder type provisions in the contracts to set the bar, to set the expectations, and then rely on the parties to work together, and with the understanding on the flexibility front that things are going to change and that we're going to need to continue to adjust things and make sure that both parties have buy-in on that.
So my position is that no, I don't think you really need much in the way of new clauses, because parties are always required to comply with applicable law. So if the law changes, the parties have to comply with it. And I hope this client is on this webinar today, because I was chatting with a client the other day, and I said, you don't put a clause in your contract that says the hotel employees will not stab the guests, because of course they aren't supposed to stab the guests, and we know that. So the same is true with everything else. If there's new standards that apply, the hotel has to do that, whether or not there's something about it in the contract. I don't think adding extra clauses makes sense. Another issue that's out there, and we're going to look at some bad clauses, another issue that's out there is by requiring new clauses, first of all, the customer is asking the hotel potentially to have different standards for every group that comes in-house, and that's not something the venue wants to do. And second of all, and this is the most important part for me, is if you are going out there trying to set new standards and trying to set the bar, as Barbara said, you could be exposing yourself to more liability because of that. And that goes down to a doctrine called assuming a duty. And again, this is black letter law. This is from a legal encyclopedia, if you will, called Restatement of Contracts. But it's actually Restatement of Torts. But I'm just giving you this law just so that you can see that it's out there, and then I can tell you what that means. What it means is if you take on the responsibility for the safety of someone else that you wouldn't otherwise have, and then you do a bad job of handling that responsibility, you could be held liable. And that's something that Barbara and I talk about a lot, because customers are out there saying, hotel, you will do this or you will do that. And if they're trying to set that standard and that standard turns out not to be good enough, they could be sued when otherwise it wasn't their responsibility. Barbara, what do you tell your clients about it?
Yeah, no, it's true. I mean, certainly I tell clients to, the practical aspects of working together with the hotel, the venue, to keep people safe are important. Whether you say to individuals, we're safe, it's safe to come out, that's exactly the very assumption of the that duty. And so, Lisa, some of the examples that you and I have talked about, groups asking the hotels or venues what kinds of cleaning and sanitizing to do. We know already there are certification standards that are out and are coming out with regard to cleaning and sanitation. From my standpoint, my group standpoint, find out about those. Do you have to bake those into your contracts? Probably not. You want to rely on that, but you want to make sure. But again, Lisa, just because the hotel would commit to that doesn't, again, guarantee, even in the best of certifications, right, that that's safe or that will work in every type of circumstance.
Well, and a good example for assuming the risk that I like to use is I see groups wanting to put in clauses saying that the hotel will have X number of defibrillators, or the hotel will have a person on site at all times that is trained in CPR. So now they're saying this is good enough. This is going to protect my attendees if the hotel does this. What if it turns out at the time that somebody drops over with a heart attack, the person who's trained in CPR is on the other side of the property, and by the time they get there, it's too late? Then the group could be sued because the family could say, you should have required somebody trained in CPR in every meeting room, or whatever the standard would be. Had the group not said anything about it, it would have been the hotel's responsibility to determine whether or not they had to provide somebody trained like that. So those are the assumption of the risk issues that I see and that are concerning to me. And again, by setting these standards, it's hard for the hotel or the venue because every group has its own standard and they can't change, on a dime or even with multiple groups in house at the same time.
Yeah, Lisa, I want to pick up on the one other example on that page, which is that the venue requires that the group be responsible for social distancing within their members, or again, akin to the face coverings, if that's the case. One of the questions that comes up a lot is whether the group can set its own rules as it relates to their meeting. And my response has been yes. I mean, just like everything else, whether it be appropriate conduct or anything else, that the group can control the environment. Certainly with regard to following laws, I mean, that there isn't necessarily circumventing that, but more so just setting the stage. So, groups that are setting rules of the road, if you want to come to our meeting, you wear face coverings, your social distancing, etc. For the venues to say to the groups, you all are responsible for that. In some respects, I'd say, well, okay, if it relates to the meeting space, but again, as it relates to the public areas of the property, we can't control that. And I know that's that shared risk, Lisa, as to what the expectations would be for the groups. But there's a lot of discussion on this in particular as well. Even if that locality says no face mask needed at your area in Arizona, doesn't mean that the group couldn't come in and say at our meeting, we wear face coverings.
I mean, the group could do that, and then the question becomes, now you're assuming that duty to say what the safety standard is, and then if it doesn't work, are you somehow going to be held responsible? And then we go back to drunk Uncle Joe, and they're not doing it, and what are you going to do? And there, again, there are no answers here, folks. These are issues that you need to discuss, things you need to think about. We can't tell you what the black letter law is because there isn't any on this.
Yeah.
I think
and you know, the best way to avoid a risk, Lisa, is making sure it doesn't happen in the first place. So I think, you know, we talk about the legal side of it, but no one wants a bad thing to happen. And I think obviously we're all aligned on that front.
Right, but the point is, as we keep saying when we're talking about this partnership, going forward when you're having your preparations for your meeting, these conversations need to take place between the group and the hotel, saying who is going to do this, who's going to do that, what's going to happen if Uncle Joe isn't complying, or whatever it is, so that you've had that figured out before the event happens. And it's going to be a new thing that everybody has to do because there's so many questions at this point, and we can't give you firm answers on that. So as Barbara and I always say, bad clauses are born of bad experiences. Whenever I see a lousy clause, I always say to the person, what happened at your last meeting? Why do you want this clause? What is it you're trying to stop from happening? There's a lot of clauses that are already being floated around out there that are supposedly approved by this, that, or the other. They often aren't drafted by lawyers and often don't do what they want to do. And we want to show you a couple that we've seen. And again, I want to emphasize, these are problem clauses. These are not clauses we're telling you to use. These are clauses we're telling you not to use. Barbara, you take the first one. What's your issue with this?
Yeah, so this one, you know, puts out the requirement that the hotel do procedures, obviously, in conjunction with health and safety, environmental provisions, to be in line with guidance with CDC at all times. Just pausing on that point for a moment, Lisa, since the beginning of COVID and, you know, early January, at least in the US, and the CDC guidance then, and how it's evolved into what was just issued on Monday, it's everything in between. So it's a moving target. I certainly don't think it's a reasonable target. Again, I think the parties should use best efforts. And again, you know, I agree that the parties on both sides should keep abreast, but just putting in this clause doesn't make it so. And, you know, certainly if it gives you comfort to sleep at night, okay, super. But at the end of the day, I'd rather know that it's being followed, and I'd rather communicate, as you said, on both sides, rather than adding in language that it only down the line potentially buys us a breach of contract dispute.
Right, and you know, adding to this, it says, oh, they're going to visit the CDC website on a regular basis. Well, for most large hotel companies, their standards and protocols are set at the corporate level. Corporate is doing that in compliance with their safety and sanitation consultants and all those kinds of things. And so, you know, this hotel in this town is not going to go to the CDC website and say, now we're going to change this. They're going to get that trickle down from their corporate leadership, as they should. And so, again, this clause isn't really going to get you where you want to be. Similar with this next one, you know, you're going to make changes on an ever-evolving basis. I don't know what that means. And then we get down to, it is the intention and the responsibility to ensure that all persons be protected by any such spread of bacteria, disease, or otherwise harmful substance. Well, what does that mean? Does that mean alcohol? Does that mean in states where marijuana is legal that the hotel has to protect you from marijuana? Those of you who go to California see those signs all over that everything in the world, you know, is going to give you cancer. So you're just putting in a clause here that's meaningless. It has no definition, and it's just ripe for somebody claiming that you have now assumed a duty that you haven't complied with. Barbara, further comments on that, or that's enough?
Absolutely agree. And these clauses didn't come from me.
No, nor me. So what are we going to do? Again, always ask the venue for its policies. They'll be happy to share them with you regarding sanitation, cleaning, those kinds of things. I do want to put in that I often see that they want to see the hotel's security plan, and hotel's not going to give you all of that, because if they tell you where all the secret hidden cameras are, then they're not very secure. But policies, certainly they'll share with you. Barbara, policies for the meeting?
Yeah, absolutely, Lisa. I think having the new spin, if you will, on the codes of conduct that many of you have been accustomed on the group side of working within, making sure folks engage in appropriate behavior at conferences, have really now extended that appropriate behavior to include what the group might want to do in terms of, you know, CDC guidelines. So here again, face coverings, distancing, etc. I think it's critically important that anybody who registers for your event, no matter where it is, understands the rules of the road before they register. And working with a client just yesterday who opened up registration, they had 15 people register, and now the group says, we're going to have these rules of the road. He said, you need to go back to those 15 people and make sure they're okay with that. And by the way, those of you who have large trade shows, events, you need to talk to your exhibitors about this too, because of course that trickles down to folks who are working in their booth too. So everybody needs to understand the rules of the road, and they need to accept those. I think a click agreement, Lisa, on that in registration would be okay. Contrast again to what I said earlier with regard to really some waiver being different. And again, keeping abreast with CDC, Department of Labor guidelines. I think with a trade show example, and I was with a group yesterday, Lisa, of large trade show organizers, you know, maybe even in advance, as many show organizers do, having education and training about the meeting and the event for exhibitors and their staff. Now, I think, again, leading into protocols on just keeping safe and clean and what the expectations are. I think, again, all of these things from my book, Lisa, are risk avoidance, and that's really the name of the game, and it's a shared responsibility, again, and I think putting those rules out there, making them clear, and then being able to enforce the rules in a way that makes sense for your organization, that does become important too. I mean, you know, we saw United Airlines now say, you don't wear a face covering, you don't get on the flight, and we can put you on the no-fly list, you know, which really is a bit of a wake-up call. But, you know, we'll see likely some organizations take a more extreme measure, and we'll see other organizations choose to leave things optional. And again, I think that's to some extent the polarizing nature of the issue as a whole.
Did we lose Lisa?
We might have lost Lisa. Oh,
all
goodness. Right. I'm sure we'll get her back on as well as we go through these. I mentioned I'll do my tap dance routine now. I mentioned about asking your vendors. So as between every vendor involved with your meeting and event, it's important to understand what your vendor is doing relative to keeping their employees safe and relative to testing and safety. Again, nothing that you necessarily have to bake into the contract, but more so that you understand that, because folks will ask you as on the group side, so you'll need to look at those expectations. So if you're in the middle of negotiating contracts for your upcoming meeting or event with an AV company or a decorator production company, ask those questions. Look, they're gonna change, and that's fine, but we need to better understand our protocols. The due diligence now standards, of course, are always high for meeting professionals, but even more so now, we've got sort of new things to add to your checklist. And again, that's the nature of what we're working with right now, and it is important to address that, Lisa. Thankfully, coming back online, I can stop my tap dancing.
Okay. Sorry about that. I don't know what happened. My internet crashed naturally. Can I get permission to share my screen?
Yes, you do. You should have it.
As Lisa gets that up, Barbara, do you mind going back to the definition of assuming a duty? We've had some folks in the chat message ask if we could just circle back on that briefly. I was thinking if that would be okay while Lisa gets the deck set back up again.
Yeah, I'm trying to figure out how to do that.
Yeah, all those sessions are recorded as long as you create an account. If you don't haven't done that, we can definitely.
Yeah, so the assumption of a duty is essentially, as Lisa said, this is sort of the black letter of the law for groups, and essentially is saying that if you render services and you said that necessary, you know, you're saying essentially that you're offering services, whether you're getting paid or whether you're offering them for free, you essentially you're subject to liability in that undertaking to do that, so that if you don't do that with reasonable care, you don't serve the burger at the appropriate temperature or health standards, then you could be essentially liable for failing to exercise that care, and then the resulting harm or risk that comes. So the concept in this way, Lisa, we've been talking about is relating to the pandemic itself, right? Someone who has a risk. And we know, and we hadn't yet mentioned this, Lisa, but folks that are in a high risk individual class that the CDC defines with chronic conditions and otherwise, again, I think that takes on a nuance on the assuming a duty as well. Would you agree on that front?
I would, and maybe I can help with assuming a duty by giving a very simple example that I often use. Pretend you are the event planner, you're having an offsite event, and you bus everybody to this offsite event, and when it's time for everybody to go back home, one of the attendees says, I want to walk home, can you tell me a safe way to walk home? And if you say, yes, walk down Main Street, and it turns out that they walk down Main Street and they get mugged, they can come back to you and say, I relied on you telling me the safe way to go and it wasn't safe, and now you're responsible for the fact that I got mugged. In that case, if you had said, we don't know the safe way, just we recommend you get back on the bus, you're not assuming a duty to protect them, and so you wouldn't be responsible if they on their own decide to walk back and get mugged. How that would apply to COVID-19 would be, again, if you assume the responsibility of telling the attendees what is safe or not safe, or what activities would be safe to do, whether it's take a mask off or not. You could be held responsible if you are telling the people what is safe when you don't have the obligation to do that. Would you agree with that, Barbara?
Yeah, absolutely. So, the disclaimers that go along with that, I think makes sense. So if you have your code of conduct, you can certainly, reference, again, talk to your legal eagle about putting in a disclaimer. These are best practices. They're not designed to guarantee that nothing will happen. Lisa, another example that I often give is in the hotel lobbies and the days gone by with the brochures for all the various activities in the area, and the little placard that says, hey, these are just some samples, right? But we're not recommending any particular one. Is another example of that. So those are all designed to essentially avoid that concept that a duty had been assumed.
Right. So again, solutions and issues going forward. We've talked about a lot of this, but the main thing, again, we can't emphasize enough, is partnership, discussing in advance how you're going to do things, what you're going to do, who's going to make sure that things are followed the way they should be followed. What else are you recommending, Barbara?
Yeah, no, it's very much that risk assessment. I mentioned just a moment ago, Lisa, within the confines of due diligence, and how organizations need to look a little bit differently at due diligence in a whole variety of settings. But for the meeting professionals working within the organizations, we always talk about certainly the importance of crisis planning. And so beyond the, what can we do before the fact to, as due diligence, checking with our vendors, finding out what their protocols are, et cetera, we should be prepared for on-site issues. Again, if this comes up, and of course, on the back end, when or if there is someone who did attend a meeting and later test positive, we have contact tracing. How does that impact the group too? So this just further emphasizes to me, Lisa, the critical need for groups to have a crisis plan. And we've said that for a long time. And then the related point to that is crisis communications. And that could be pre-crisis, right? But having those queued up and ready to go, having communication professionals really work on those in advance so that if, gosh forbid, something bad does happen, there is a way to respond to that. And certainly as we segue here, Lisa, for you and I have talked about the impact on contracts now in different settings, whether the contract was signed, I know before the COVID-19 versus now that they're going forward and signing new contracts.
Yeah, I think you need to focus, as Barbara already mentioned, on the fact that the meeting industry has responded very well to this situation. Nobody was arguing, from March until now over whether or not events could go forward. Everybody worked together. They tried to rebook. They tried to do other things, even though there was no mention of anything about COVID-19 in the contracts, because obviously nobody had ever heard of it. You do need to remember that if you're going to rebook an event or do something like that, you're either entering into a new agreement or you're entering into an amendment of your contract, not an addenda. Everybody in the industry uses this terminology the wrong way, and Barbara and I are on a two-woman crusade to get everybody to say amendment instead of addenda. But if you do decide that you're going to rebook events, you need to remember to look at the entire contract and say, what else is changed because we're changing this event? We're either moving it forward in time, or we're adjusting the size, or we're doing something like that. You need to look at every provision. How does this change your cancellation? How does it change your attrition? How does it change your meeting space, if it does? And all those things need to be addressed in your amendment or your agreement to go forward.
Yeah, absolutely.
Deposits, when are they going to happen?
One add-on. Oh, sorry.
Go ahead.
I was just going to say one add-on
Oh.
to that piece is that if an amendment is being entered into in consideration for waiving cancellation fees, right, for the meeting that didn't happen, that this would be the new meeting, that there be language to that effect in the amendment. So many times a group say, well, we made this deal and we signed this amendment. And I said, well, where does it say that, you don't owe fees for this other canceled one? Does it? And whether that would come to issue, who knows? But at the end of the day, an amendment is your opportunity to build that in, the expectations for both parties.
So going forward, will venues be flexible? I think in the short term, yes, certainly the hotel's position is that they'd rather have an event than no event. And so if you're talking about things in the short term, certainly they're going to be willing to work with you if it's September or August or October or whatever. But I'm having customers come and say that they want to cancel for June of next year. And, hotels aren't going to be flexible about that because that's too far in advance. Nobody can know what's going to be happening then. So, I think I anticipate what's going to happen is that booking windows are going to get shorter. People are going to wait to book their events until they have a better handle on what's going on and what they can and can't do. And I think hotels, again, will initially be flexible, but they're not going to be flexible for 2026.
Yeah.
And it's important to not expect that flexibility to be the new normal, because we've all got to get back to business and, working together to get back to business, and being flexible now and getting back to the old normal to the extent you can is going to be very important. Barbara?
Yeah, no, I agree, Lisa. And obviously also important is the function space. So the function space that may have been booked for the initial meeting, I would tell my clients to just assume the worst and book as much space as you can, which I know the hotel people don't throw rotten tomatoes at me, because groups are already space hogs. We understand this. But obviously the intent there is just in case social distancing kind of remains the norm, that there would be enough space. And then again, to your point, Lisa, that there would be a provision for the group and the hotel to work together to evaluate that going forward, obviously in the group releasing space if it would need to.
All right. So, and I think I'm going to skip over this so we have enough time for questions. Try to work on business solutions. It's not one size fits all, go through all those things. Oh, here's a good example of one that I did have. If you're coming to a hotel to cancel an event, say in October, and the hotel is saying we could still go forward, if you've got a good reason why you think you need to cancel, share that. We had a wedding where the group said, look, I have an autoimmune disorder. My doctor says I cannot travel until there's a vaccine. That's reasonable. We let them go. A different kind of event, we might not have let them go because October is still too uncertain. So again, give your reasons, be reasonable, and the other side's going to work with you. Again, always approach it as a discussion, not a demand. And before we go into our questions, we've got some polling questions, and you're now going to see me actually figure out how to do this. So,
as Lisa breaks up those polling questions, I'm just going to provide a brief voiceover here. I'd like to thank Barbara and Lisa firstly for delivering an awesome presentation number 2. I wanted to reiterate the goal of the partnership HopSkip and the Legalese with the ladies team has formed, which is to provide value and education to the meetings industry. And in addition to providing education through these ongoing webinars, HopSkip is very interested in showing you how our platform can enhance confidence in your sourcing process. And we'd love the opportunity to schedule a demo with you to do so. So if you have any interest in checking out the platform, please let us know by choosing option 1 under question 1. And then secondly, as I mentioned, we will continue to roll out these webinars. So we would love your feedback on any future potential topics. So if you could please provide your input here for question number 2, that would be great as well.
All right, so now we end the polling and we're going to go into the Q&A. So Sean?
Awesome. Okay, so first question of the Q&A. Is it a good idea to take temperatures when participants enter the meeting rooms?
So, I know there's been some guidance, Sean, on this and the CDC guidelines that came out on Monday, and there's lots of other guidance on it. Obviously, I think we all also understand that folks can be asymptomatic, so that a temperature check isn't necessarily the best way to measure. Some organizations, many of you, if you've had contractors in your home in the last week, or you've gone to get your hair done, which some of us here in Illinois are dying to do, that they have you fill out a questionnaire. And so we're seeing more of those questionnaires factoring into meeting registrations as a way to also vet that. But, some groups may take to screening on site. I know, for example, here in Chicago, a lot of our office buildings are having, sort of walk through temperature checks as if you would be walking through, metal detector at an airport. Again, I think I go back to that assumption, assuming a duty. Is that going to, is that going to help things? There are folks that also take on the position that that's sort of a private issue. I know I've seen a video put out in our industry of a trade show where, I don't want to forget the badge. I just have to put my wrist up to a temperature check when everybody behind me, it's like, gosh forbid I have to step on a scale, right? Everybody's going to see it. I don't think it matters when my temperature runs low, but who knows? And so I don't know. I guess I'm agnostic on the concept. Certainly, if groups feel that it's important for them, they can do it. But Lisa, I don't know what your thoughts are on that question.
I think there's a lot of questions involved in this. Who does it? Do you have to hire a nurse? Who makes the decisions? Who tests the equipment to make sure that it works? A friend bought me one of those, Zapper temperature gauges, and we've been playing with it around my house, and it gives 5 different temperatures every time you do it. And so I have a lot of concerns about it, and the question becomes, at what point do you say you can't come in? Is it 100? Is it 101? Is it 102? I don't know. I would be worried about the assumption of duty on this issue. Unless you have a medical professional guiding you on this, I'm not sure that it's going to be helpful to you. That's my thought.
Great, thank you guys. Another topic that's come up pretty frequently over the past couple of weeks, and I know it's also popped up in the chat throughout today's webinar, and something we haven't really touched on, which is how does this differ when you have an international meeting, specifically in Mexico or the Caribbean? Does anything differ?
I always say, force majeure is a lot like what the Supreme Court said about pornography. It's difficult to define, but I know it when I see it. If you've got an international meeting scheduled in a place where people are not allowed to come from or go to, if the borders are closed, you're excused from your event. That's pretty straightforward. In terms of going forward, once those borders reopen, again, I think it's going to depend on what the CDC recommendations are and what other expert recommendations are. What do you think, Barbara?
I agree, and I think it gives a group a chance to evaluate its international attendance. Are there different ways that they could deliver content to folks who might be restricted from traveling? I think that's to be expected. Obviously, checking the local orders in that country, and then border restrictions. Again, air carriers have the restrictions as well. So there are a lot of issues involved in traveling internationally, of course, but beyond that, in meeting in different countries, you can't assume that the protocols are the same as they are in the United States.
Yeah, and technology, as we've all learned in the last few months, allows us to do a lot of things we didn't really think about before. So, when you have events where somebody's saying, well, all of our people were coming from overseas and now they can't come, does that really prevent your meeting? Because couldn't those people participate virtually and the other people participate in person? I think we're going to see changes in the way meetings are conducted as people are uncertain about what they want to do or not do. Maybe half the people are happy to go to wherever it is and want to meet in person, and there's still people that are hesitant, and so they want to participate virtually. We're going to see those kinds of changes happening too.
Yeah, the hybrid term, Lisa, takes on a new meaning in that regard, and I think that's a safe way that a lot of groups are trying to dip their toe in the water.
And I was just gonna mention, exactly like you two taught us on our last webinar, the importance of stating, the purpose of your event as well, and making sure that's known and documented and communicated. Okay, the next question that we have from the audience members, how would the following scenario work? So in this scenario, the group is having a meeting at a hotel. And for example, they're asking all of their attendees to wear face masks and abide by certain requirements. But they would have concerns that another group or meeting would be happening at the same time in that same hotel and not following the same guidelines as their meeting or group. How would you advise that group or meeting to proceed?
Those are one of the, go ahead, Barbara.
I was just going to say, I mean, that's just the natural outflow of what we will always deal with.
Right.
Face coverings are required inside buildings, as they are here in Illinois, and another group isn't doing it, that's a problem. If they're in a city where they're not required and our group, your group wants to do them, that's great, but they should understand when they leave that room, not everyone's going to have that. And that's, goes back, Lisa, to, again, saying just because we have it doesn't mean that we're assuring that everyone else is going to wear it. But it will cause a stir, I'm sure, for many, as it has, Lisa, for you when out and about in Arizona.
Yeah, I mean, again, I've experienced it myself that, the compliance with face coverings so far has been, spotty, and it's just part of the way that you have to deal with it. So I think that in that scenario, the customer having the event needs to tell its people, look, these are our rules, our protocols for when you're in our space or attending our events, but we can't control what's going on outside of our event. And you need to be aware that that may be what happens.
Great, thank you, Lisa. This has been touched on a few different times, I know for sure, and I know this is something the HopSkip team and the Legalese with the Ladies team have talked about quite a bit, but I've still seen this question pop up a few times, so I'm going to ask you both to please just touch on this topic again, which is the following scenario. What if the city you are located in allows a hotel to be able to perform? However, the group/events home city has a stay-at-home orders in place or is limiting travel. What do we do in that situation?
If everybody that's coming to the event is prohibited by law from going, then arguably it's a force majeure. Now, this would be very dependent upon what the language of your contract says and when it says that the group is excused. But again, this is one of those unique situations that there's no legal precedent on that. And so you're going to have a conversation about what you can and can't do. I mean, typically, if people choose not to come to an event, that's an attrition issue. But if they're legally prohibited and everybody can't come, then I would think that's probably a force majeure. Barbara?
No, I agree with you, Lisa. The nuances as well as the can't come comes up a lot of now with corporate travel restrictions, right? I'm not going to get thrown in jail or have a big ticket written, but I may lose my job or I might have to quarantine. So, I mean, I'm raising that point to say, and I agree with you that so much is dependent on the force majeure language. I think the evaluation of can't, won't, you and I talk about that a lot. The nuance with the travel restrictions, definitely adds that into play.
Yeah, and just so we're clear on that, Barbara and I agree a lot. But I'm not sure we agree on the corporate travel restrictions, because to me, if a company says our people are not going to travel, that's their business decision to make, and that's fine, but that's an attrition situation. That's not a force majeure. You can't create your own force majeure under the law. You can't say, I'm adopting a policy that we're not going to do this. Oh, now we're prohibited. It's a force majeure. That's not the way it works.
But if in the contract force majeure provision, we say that the right is triggered by a certain percentage of people not being able to come, that likely would be a case. Again, it's the kind of debate that you all are seeing as well out on the street, and we're obviously seeing it too.
Right.
Awesome. I think we have time for one last question here, and you briefly touched on it throughout the presentation, but I think it would be good just to expand on it for a few. Is it appropriate to ask the hotel for a risk management plan in writing and what to look for in that plan?
Again, the hotel's not going to give you everything in their risk management plan. They may be willing to give you some portions of it, but hotel security plans are confidential, they're proprietary, and a big part of what makes a security plan successful is that people don't know what it is. So they're not going to tell you everything. They'll certainly agree for their director of security to brief you on their protocols and procedures and give you non-confidential portions of the plan, but they're not going to give you everything. Barbara, what are your customers or your clients doing?
Yeah, Lisa, no, it's definitely on the security front, understand and agree with that. On the health, safety, wellness front, I think asking for the information, be it in writing or otherwise, is a good idea. I don't think it's necessary to bake it into the contract. I think it's better to understand it, and then it's better to update it. And again, on-site training, that pre-con meeting becomes important because not only should you interface with the security issues, you should interface with the management on health and wellness of the attendees. What do we do if, right? So I think all that becomes important too, but really understanding. And I think in order for some groups, in order to get people to come to the meetings, there needs to be an understanding of what everybody's sort of doing along the way from when I get on the plane to when I go through the airport and check in at the hotel and everything else. So at the end of the day, I think it's helpful to gather the information, but I wouldn't be gathering it as a way of using it as a sword, right? If somebody isn't complying with it.
Great. Thank you, Lisa. Thank you, Barbara. Appreciate it. I think we're just about out of time, guys. One last message we'd like to deliver to you is, firstly, thank you all for attending. You'll automatically receive an email early next week with a link to the recording. And lastly, as mentioned in webinar 1, in efforts to help out while we're all dealing with budget and time pressures, HopSkip is currently running a promotion to allow planners to use all of our premium features at no cost for your first 3 RFPs or for 3 months after sending your first RFP. We'd love the opportunity to show you the HopSkip platform and hear any feedback you might have on today's session. Feel free to contact us at info@myhopskip.com. Have a wonderful weekend and happy Juneteenth. Take care, guys.
Thanks, everybody. Bye.